Let me welcome you all. My name is Refik Hodžić. I am the moderator of this session, which will discuss what Bosnia and Herzegovina as a society can do with the legacy of the tribunal in future for the benefit of us all. Before I give the floor to Judge Fausto Pocar from the tribunal, let me give a brief introduction to this session to honor a great and renowned expert, late Professor Vojin Dimitrijević, who on one occasion, while talking to a Serbian journalist who wanted to know why us, why did the gavel of international law had to hit us, while was there no tribunal for Korea, for Vietnam, for various crimes? Why are we the ones subjected to international law? And Professor Vojin answered him, "We should be grateful for that, my son, and not bitter, because the fact that an international body has been established to investigate the most serious crimes committed in the area of the former Yugoslavia, to bring to justice those most responsible for those crimes, and to establish some of the facts that would never be enlightened without such an institution, put us in a position to think about how we can benefit from this. How can our societies benefit from this? But as we all know, much more efforts are being invested into undermining the work of this institution and undervaluing the facts established there. We will start the session with the question for Judge Fausto Pocar, former president of the ICTY. I will kindly ask him to tell us his point of view, to share his point of view on the facts and judgments rendered by the tribunal in the context of benefits for the society in Bosnia and Herzegovina. What could be other benefits of the work of the tribunal and its achievements, in addition to the fact that criminals were apprehended and tried, and what is your perspective on possible uses of the achievements of the tribunal in dealing with the past in this region? Judge Pocar.
Thank you, Refik, and thank you for leading this panel, which looks to be very important and very significant for the success of this conference. Let me perhaps start taking on your questions you put to me, and I will try to answer them as best as I can. But I would like first to start with something that has been said this morning, in which I believe should be taken care of if we want to maximize the positive aspects or the positive elements we can draw from the experience of the ICTY. When the tribunal was established, it was entrusted with a number of tasks. First, the judicial one, of course, and everything rotated around that judicial task. But if you look at the resolutions of the Security Council, you find a number of other aspects: reconciliation, rebuilding societies, a number of things that are in the preambular parts of the resolutions of the Security Council, and have been interpreted as if the tribunal had been given all these tasks, which would have been a bit strange from a political body not to think that a court can do certain activities but cannot do other activities because of its nature. So sometimes there is the idea that all the problems should have been solved or should be solved by the tribunal, by the ICTY. And this is not the case, of course. This cannot be the case. I say that because if we take the attitude that the tribunal should have done everything, at the end, we end up saying that, well, the tribunal has not done it, and so there is no way of doing it. We should take for good what the tribunal has done, but also within the limits of the activity of a court. So, for instance, when we consider that the tribunal should have adopted measures of reconciliations, this is fine. In a way, we can say it, but the fact is that the judicial activity of the tribunal can help reconciliation, but reconciliation needs other measures as well, needs a number of other interventions, political, from the international community on one side, and on the other side, and more importantly, by the people concerned in particular. In a way, it's more than natural, I would say, not blaming anybody for giving a wrong assessment of the role of the tribunal, but it may be more than natural. The ICTY is seen as the institution that has to achieve all of the goals of an efficient transitional justice and rebuilding of a thorny society ravaged by a war. But there is a limit to what the judicial body can do. Those who work, Refik himself, in transitional justice know very well the wide range of measures that have to be taken in order to effectively bring about justice and reconciliation. Even the judgments, and to come to the point raised by you, even the judgments of the tribunal cannot be taken, as I heard this morning somebody saying, as the truth against the false assessment of the situation. There is always, as somebody else said this morning, a judicial truth which does not necessarily cover all the truth, because it depends how a case is prosecuted, for instance, whether the witnesses are found, the right witnesses that will give the information needed and give the evidence. If that does not happen, the final decision may suffer here and there some problems. It would be wrong to say, for instance, that for instance, that as has been suggested this morning at a certain moment, that it should be even criminalized the fact of saying that the decision of the tribunal does not reflect entirely the truth. Because there, the risk is to go into another problem, which is to build a society where the freedom of opinion and of expression is not allowed completely. We know that this has been a problem in many countries to criminalize for instance, the speech of those who negated the crimes committed by the Nazis during the Second World War. But in most countries, this has taken many countries have taken a different approach. And in any event, the criminalization is never done in a way that should affect completely the freedom of expression. So we must be very careful in saying we have to take the ICTY as it is fully or go against the ICTY fully. It's a problem of finding a good measure in assessing that the ICTY, what it did is, and does, is to give a contribution, and I think a good contribution, to the assessment of the situation and a good contribution for a basis for reconciliation. There are things, for instance, and I want to be quite clear, it's not that everything is doubtful. I'm not saying that anything the tribunal has done can be questionable. I find that in principle, when certain facts have been established without doubt, beyond reasonable doubt, as it is the standard of the tribunal, and have received a certain qualification, legal qualifications, the fact that the qualification comes from an authoritative body bears does not exclude somebody saying this qualification is wrong. But in fact, the authority of a court that gives a certain qualification has to be respected. I mention, because this has been discussed in various fora, the question of Srebrenica. Srebrenica is clear that there are certain facts that have been assessed. There is no doubt about those facts. They have been assessed by the ICTY. They have been accepted as assessed by the International Court of Justice. So this is clear. The facts are there. The qualification that has been given by the ICTY as genocide in the Kirchner's case is a qualification that comes from an authoritative body. The ICJ could go for another qualification, but they decided to make the same qualification. So they accepted, it's another authoritative body that accepted this should be regarded as genocide. Now, there are little doubts that this is the qualification. If anybody can go and say something else, but the force of the qualification given by these two courts is extremely important. So I believe that we should take into account all these things in making use, and I take the point made by my good friend Vojin Dimitrievich when he said, when you have you are under the attention of international law, you should make use of that and try to follow what international law decides. For instance, one issue which is extremely important, in which the tribunal did a lot, but this because it was within the powers of the tribunal, was to help enter a sort of partnership with local judiciary in order to apply same standards. It's for the domestic judiciary at this point to make use of these international standards, import them in their jurisprudence, which would put completely the countries in conformity with international law. This is one of the examples of what can be done, but it needs the cooperation, of course, by the country. I don't want to abuse my time, but there is one issue I want to make. If I can do it later.
Can we come back to it after we go through the panel?
I will, thank you. I will follow up on what you've said. decisions of international tribunals, such as the ICTY, even though they do not present the absolute truth, but rather judicial truth, are very important in polarized societies such as ours, where, let's face it, even the war has ended. There is a desperate fight going on for the ultimate truth. It is my truth against yours. I will never acknowledge genocide in Srebrenica or vice versa. So what we can stick to are facts established before the tribunal exactly because of the standards that you just talked about, the highest international standards of adjudication of facts and establishing of facts beyond reasonable doubt. I have a question for our next panelist, Branko Todorović, the president of the Helsinki Committee in Republika Srpska. Do you see, can you perceive a future situation where facts established before the tribunal and judgments of the tribunal are accepted as such in the Republika Srpska and are made part of the curricula for schools in Republika Srpska, so that the children, for example, living in and around Srebrenica would know about what happened? It is not my intention to put Republika Srpska in any kind of focus, but since you live and work there, I'm asking you about that particular location. And let me remind you that you have up to 7 to 8 minutes for your introductory speech. Branko, I will try to be as brief and concise as possible. I did prepare a presentation for today, but I just put it aside. I think that the dynamics of this conference put us before a new challenge. Let me answer your question. I don't think that the situation you just spoke about will ever happen, because certain requirements have not been met in the Republika Srpska and Bosnia and Herzegovina and even the region for something like this to happen. We are far from facing the past, dealing with the past, accepting the truth and the facts. Why is that so? It doesn't require much knowledge or expertise to explain the reasons for that. But as you said, the versions of the truth are mutually exclusive, and the societies are still in open confrontation. It is only the question about how willing we are to acknowledge the existence of such confrontation. But the fact is that none of the leading political platforms in Bosnia and Herzegovina have abandoned the wording used in early 90s. In addition to this disappointing fact that we are still in this combat to which I see no end, we have to wonder about our own humanity. Let us revisit 1992. Let us think about a policeman who is 40 or 50 who rapes a 12-year-old girl. That happened in Bosnia, and some of those people were convicted before courts. Now, my question for you here, in this room, or outside this hotel, or in Bosnia and Herzegovina, would be, is there anyone who supports such a vicious deed? Everyone will be unanimous in rebuking that. But let us go back to 92. I worked with a group of students and I read parts of one indictment, war crimes indictment, to them. And I mentioned the location, and the location led to the context about who were the perpetrators and who were the victims. It was a mixed group of students from the region, Croatia, Serbia, and Bosnia and Herzegovina. And then I noticed discomfort with students who were a part of the ethnic group of the perpetrators, as well as the feeling of victimization on part of the group of students from the ethnic group that was the victim of this crime. It was a distressing scene, what was described in this indictment. A group of paramilitary members led out a son and a father and tortured them in most brutal way. Then they asked this father if he has any more children, and the father answers no. And a member of the paramilitary grabs the rifle, kills the son, and tells the father, now you have no children. Then they take out two brothers and force them to perform most brutal, to engage in most brutal acts, and then kill them. Once the location of this event was established, any further communication was impossible. When I worked with another group of students, I did not mention the location or the context so that they could conclude where it happened. They could suspect it was Bosnia, but we could have said that it was in Rwanda or somewhere else. And I asked them what they thought about this. Some of those students were law students. They were all shaken, and they all agreed that it was a horrendous crime and that those who committed the crimes should deserve the most serious punishment, and that they cannot disregard this horrific content, dehumanization, which was present in abundance in Bosnia and Herzegovina. I know many of you here, we cooperated in the past, but we find ourselves in different positions, and we should think about how we, as citizens of this country, through our work, know very well what is a crime, what should not be done, what kind of crimes were committed against civilians. We know the difference between building a house your entire life and destroying that house with a dynamite or an explosive in a matter of seconds. And then we ask ourselves, if we are also ready and we can tell the difference between the right and wrong, why then do we allow some elements concerning our identity or context to drag us into this circle and carry the burden and start justifying something consciously or otherwise, and try to justify one crime by comparing it to another? What is happening? The tribunal has done its share of work. We can agree or disagree on its success, and lawyers will discuss its legacy and its results for years. But what tribunal cannot do is to make people in this country become human beings, awaken their humanity. We should not say that I know better than others, and I know that you too wouldn't do the same, but I ask myself, why today do we have victims which are on an equal footing and whose ethnical background should not be in the forefront? The politics that made them victims and did not try to avoid victimization, the politics that committed ethical cleansing and horrendous crimes, that the same politics are using them. We also need to capitalize on the possibilities of social networks, but the media remain very important, and one of the media reporting on war crimes cases most consistently, I would say, is BIRN. Anisa, what are the obstacles you have to overcome in your work? What are the necessary changes, in your opinion, to increase the impact of your activities? What are the problems of the approach of the media to the issues of war crimes? Thank you, Refik. Good afternoon. We talked at the previous panel for an hour and a half about the importance of the media for informing the public on the facts, even though there are different aspects of the truth. A fact is still a fact, and it remains a fact after the judgment. Media are indeed influenced by the ruling political parties in Bosnia and Herzegovina. According to the latest research, over 95% of all printed and electronic media is completely owned by the political parties. It is therefore unrealistic to expect some change in the editors' policies. What are the obstacles faced by those who want to report differently, distant from all the political and other influences that aim at denial of all judgments, at strong criticism against everything achieved by judicial institutions? What's left are few media houses that would like to cover trials objectively, and when they want to do so in a manner that BIRN and SENS do, they are faced with the problem of the denial of the legacy of the tribunal based on transparency. We are all aware of the criticism of the tribunal regarding their poor outreach policies and so on. We are also aware, however, of a rich archive of open public documents of the ICTY available to everyone interested. And over the recent period of time, we've seen a very strong outreach program launched by the ICTY. Judge Pocar talked about how it is impossible to say that the tribunal should have done everything, and I agree with that, especially because the tribunal made some very good practices, and one of them includes transparency. Throughout the day, we have been listening about the problem of collective responsibility. How do we deal with it as organizations, as individuals? Personalization of guilt is one of the greatest achievements of the tribunal, but one of the biggest problems is how to make those achievements available to the public. Early this year, the Court of Bosnia and Herzegovina rendered a new rule book seriously limiting access of the media and any members of the public to judgments and verdicts of the court. The Prosecutor's Office of Bosnia and Herzegovina in February this year withdrew all indictments from public access. The verdicts have been anonymized, only initials are used, and since then, 5 second instance and 4 first instance verdicts were published with anonymized information. We do not know the names of the convicted persons, and we will never learn them. The court also decided that only 10-minute portions of recordings can be issued, anonymized and edited by the presiding judge. Usually those are recordings of the beginning of the hearing. The court said that they followed the Agency for Protection of Personal Information. However, such practice is in contravention of the practice of the European Court of Human Rights, especially when we talk about genocide and crimes against humanity. This does not only pertain to influencing public perception, but also to the fact that by this, laws of Bosnia and Herzegovina are violated, such as Article 10 of the European Convention on Human Rights, which is an integral part of the Constitution of Bosnia and Herzegovina, also International Covenant on Civil and Political Rights. Finally, these instructions also undermine the entire purpose of the Court of Bosnia and Herzegovina and the ICTY in that respect. If the accused had a fair trial, if the trial was open for public, there is no reason whatsoever why the identity of the perpetrators of the crimes should not be known in the end. Why wouldn't the location of the crime be known? Why wouldn't the institution involved in the commission of the crime be known? Especially when we talk about personalization of guilt as not being the final instance, as there is a need to prosecute the institutional structure behind every crime. This also encourages speculation about the actual identity of the perpetrators, and this will seriously undermine further activities of the court and the use of the legacy of the ICTY. It will also negatively affect public perception of the activities of the Court of Bosnia and Herzegovina and the ICTY, and the public trust in the court is already fragile. So the ones who will profit the most from this are manipulators or political stakeholders. This is a somewhat peculiar strategy by which the court tries to protect itself. We are talking about future here, and this is something that will definitely not assist future generations. Limitation of information on the current cases greatly negatively affects the judiciary and makes the legacy of the tribunal devalued for future generations. There should be a serious position taken on this issue by both the ICTY, the residual mechanism, and the Court of Bosnia and Herzegovina in that regard. Serious analysis is required of consequences of recent decisions of BNH. The judiciary because they put in question the overall legacy of the tribunal. What will be held behind the locked doors of the national institutions? And the lack of relevant reactions and instructions by the tribunal will aggravate things further. Let us imagine a verdict saying that the Holocaust was masterminded by A.H., who commanded over the army in municipalities A, T, D, and others. I'll leave it to you. Thank you, Anisa. Since we've seen some similar problems faced in other societies, we can say with confidence and certainty that this is unprecedented practice, where in cases of such an enormous importance for the society, judicial records that result in a verdict are swept clean of any information. If there are any productive results of this conference, at least there has to be initiative for something to be done in this regard. Something has to be changed. I see judges from the Court of Bosnia and Herzegovina here. There are legal mechanisms. If the law has been violated, that should be addressed, of course, but this is unacceptable, especially if we talk about the legacy of the tribunal. Let us not forget that the Court of Bosnia and Herzegovina tried in a certain number of the tribunal's cases, which will then be cleansed of all the facts as any other case. The tribunal plays a very important role in addressing this issue. I could talk a lot about what the panelists have said, but I will leave the floor for discussion to you. I have to pass on the apologies of Mr. Tikvesha. I hoped that he would join us, because the perspective of institutions working on building the peace is very important. I see Aco Trifunović from Banja Luka. Maybe we could hear from him later on. However, Amer could not join us for some health issues today. I've seen several hands raised. I will note 5 questions and then we will discuss them. You will have 2 minutes for your questions. 1, 2, 3. 3 questions, 4 questions. Thank you for the 2 minutes. If I came here from Srebrenica for 2 minutes, then I can return the microphone. There are a lot of us here and everyone wants to talk. I don't know who to ask a question. I come from Srebrenica. You know that Srebrenica is a symbol of hardship, and that the Memorial Center is a shameful reminder of what could have been prevented from happening in a protected enclave. You said that the definition of war in Bosnia and Herzegovina is not known. It is very well known, only it is contained in documents that were subject to an agreement with Goran Svilanović and Carlo Del Ponte, which were marked as classified. Those are the documents containing the truth about Bosnia and Herzegovina and about genocide. You said it is not important how much the criminal would get. So, it is important. What is the message from the court if the criminals are awarded with short prison sentence? We know that we cannot bring the past back, but we can do whatever we can to build a future for the future generations. We can do something to prevent that any mother in future would find herself before a dark pit looking for the remains of her child. Everyone should know the truth about Srebrenica. The schools are so close to the memorial center and yet so far away. We have visitors from the US, from all over the world, but we still don't have visits from the schools in Srebrenica. They carry one version of the truth from their house and the other version of the truth from their school. It is very important to store the archives of the tribunal not in a single location but in backup locations too, because it can be easily distracted and it can be easily falsified. A lot of what belongs to us, to our museums, to us victims, has been destroyed in the tribunal. Carla Del Ponte destroyed evidence in the ICTY, but this is the subject of legal proceedings that were initiated. Thank you, Hatija. You said that someone here said that the definition of the war is not known and that the length of punishment is not important. The microphone is off. The microphone is not working. I agree. A lady behind Mervan wanted to say something. So you didn't have a question, basically, for the panelists, but those who spoke earlier. I am Miloslava Jakovljević. I come from Banja Luka. If we can have joint armed forces, why cannot we function together? I always compare these times with those in the former Yugoslavia. No one denies the number of victims in the former Yugoslavia. We are all brothers here. There were more victims in the former Yugoslavia in 1962 than there have been in the previous war. There has been so much progress made between 1945 and 1962, and look at the regress we have experienced over the past few years. You, from the non-governmental organizations that are officially registered, that have the opportunity to speak publicly, you should invite the politicians to stop taking us back. I was a member of two political parties, non-Serb political parties. History is terrible and war is terrible. We should not allow the repetition of that. We should have permanent peace. So everyone who has the opportunity to appear and speak publicly should criticize all those who prevent us from progressing.
Govorili smo ovdje, znači...
Ako možete samo da se predstavite.
Can you please introduce yourself? I'm Zia Smailović. This is the third time I'm introducing myself. I have a sore throat. but I will be very brief. We spoke about judgments. Judgments have to be accepted. They were rendered based on facts. But we also spoke at the previous two panels that victims of the past aggression and war and genocide should be put in focus. And in order to do that, we have to bear in mind that the judgment that you spoke about, in my humble opinion, contains one trap. And it is only a judicial judgment, verdict. It does not contain a legal sanction in its reasoning. Had it had legal sanction, then it wouldn't have happened that a war crimes convict, upon serving the sentence, comes back to his place of origin and is received as a war hero. If a certain sanction was contained in the judgment itself, then things like that would not be happening. And practices like these do not contribute to transitional justice. Those among us who represent the victims are frequently in the situation as we are today to deal with repetitions. Some of us come here ready to accept and acknowledge diversity and difference, whereas others come to spread hatred and introduce confusion. I was not raised in hatred, I was raised in love. I'm also a person whose 35 family members were killed, and I do not hate anyone, but I'm forced to listen to hate here today, hatred here today. Victims want justice. They know the truth. They want justice and satisfaction through that justice. That is imperative. If the Court of Bosnia and Herzegovina, which is kind of a successor to the ICTY, you are more familiar with that than I am. If we will see from the Court of Bosnia and Herzegovina that the persons brought in direct connection with the murder of my father are sentenced without satisfaction for me as the victim of their crime, then I don't need such a judgment at all. Let me please clarify. Tell me if I understood you correctly. When you say legal sanction, you are referring to the judgments of the tribunal and the need for a mechanism to prevent the questioning of those facts. Yes, to make it a part of the verdict, regardless of whether it is a verdict judgment of the tribunal. None of the 161 judgments of the ICTY contains any sanction that would say this and this person as a convicted war criminal has no right to run in the elections, and so on and so on. The answer to this is very clear. It is not up to the judgments, but to our own laws. The tribunal cannot order in its own verdict that a person cannot run in the elections in Bosnia and Herzegovina. It is a matter of our own legislation. It is the problem of the ICTY judgments. And everyone will agree with this, the scientists, the sociologists, and lawyers. I will give the floor to the judge to answer this. I'm not a lawyer, so I come from mothers of Srebrenica and Žepa. I'm a bit shaken by the presentation of Mr. Branko, who said that the recent events will not soon become a part of the curriculum in schools. For as long as the children are unaware of our past, I believe our future looks bleak. I am moved by what Alma Mašić does with the youth initiative. That is commendable. I was there in Belgrade when they fought to prove the truth about what happened in Bosnia and Herzegovina. I witnessed their efforts, and I would really wish for all governmental and non-governmental organizations to work with the youth to bring them closer to the truth, because without truth there will be no reconciliation and no peace.
I think we have another question. Please pass the microphone. My name is Rajesh Faked. I am the presiding of the Association of the former camp inmates of the Brčko district. I want to say something to join in the discussion, having heard what others said and people who were sitting at that table. I am seriously disturbed with hearing about different events that had taken place in Bosnia and Herzegovina and in Brčko, having heard that there was an aggression on Bosnia and Herzegovina, and in Brčko there were camps and then mass grave sites, then exhumations, then 4 collective burials, 275 people were buried, women and children, and that more than 3,000 people were detained in the camp in Brčko. I'm saying this because recently in the Brčko district, what Madam Alma and Mr. Todorović spoke about, and Anisa from BIRN, what I undertook is something that we should all do in Bosnia and Herzegovina. What I'm talking about is that I recently established a memorial room. It is a permanent exhibition in the hangar in the Brčko port where the genocide took place. I received a visit and immediately afterwards, and I received a letter from the Helsinki Committee for Human Rights of the Republika Srpska, Madam Aleksandra and Tanja, brought school students, around 20 of them from Brčko, Bijeljina and Tuzla, to visit the memorial room. The children were impressed by what they saw, and the very fact that they could learn from that exhibition about what happened in Brčko proves that we can do something to foster reconciliation. My question to Mr. Pocar is, for how long will the people from the military and the police structures and the government of the Brčko district who have still not been prosecuted will be prosecuted if we know that there was genocide in Brčko? I want these people who are still at liberty to be prosecuted as soon as possible. I don't know who is to blame for that. Is it the HJPC or the Court of Bosnia and Herzegovina or the Brčko district, the judiciary in general? I don't know, but I want these people to be prosecuted as soon as possible, and that all war criminals in Bosnia and Herzegovina are prosecuted as well. Thank you. The gentleman over there. I will introduce myself once again for those who were not here this morning. My name is Nigel Committee. I'm the head of the organization of the missing persons of the Republika Srpska and former camp inmates. I don't want to repeat what I already said. I am not provoked, but I am inspired by previous discussions. We hear some stories about reconciliation, and then you hear statements like built on genocide, created in blood. Are we going to go back to the year of 1389 or 1941 and discuss genocide? Please, should we go back to 1941? Just a second, please. Please, let us maintain the dignity of this gathering and don't talk about 1389. If you have something to ask about this topic or follow up on the discussions, please do. Why am I saying this? I'm going to say something of my own. My grandfather died at the Solemn Front in 1942. In 1942, in the German archives, you can find this information in the Drakulić settlement near Banja Luka. 2,300 people were killed in one day, 551 children, 74 of my closest relatives, because my father in 1939, 74 people from the Mitrović family were killed. Is that genocide? We constantly hear statements that Republika Srpska was created on genocide. Republika Srpska was created where genocide had taken place in the past, and the Serb people did not defend themselves like Bosniaks didn't. I'm now talking about the similar situation now. If we were talking about the past, do you have a question, please? You have 2 minutes. We all had 2 minutes. If you think that we have to listen only to you, then I have nothing else to say.
Ja se izvinjavam, prethodno pozdravljam sve.
I apologize, and I would like to greet everyone. I have been listening. Marko Grabovac, my name is Marko Grabovac, the head of Association for the Looking of Imprisoned and Missing Citizens of the Brod municipality. My brother and my mother are missing. One of them was detained in the camp. Did I kill them? I ask myself. Was I the one who killed them? All the stories I heard since this morning have no essence. You did not mention at all the dozens or the hundreds of camps where Serbs were detained. What I know, working in this line of business, in Brod, there were 10 camps for Serbs. More than 2,000 persons were detained in those camps. Large-scale rapes. I can provide you with the lists of women and children who were raped. I have the proof of that, and I can add some other information to that, which is indisputable. In 2002, we handed over to the Hague Tribunal the criminal report about the crime committed in the territory of Brod municipality, where even an aggression was committed by Croatia, assisted by the Muslim and Croatian paramilitary units. They tied their flags and started with the looting and the pillaging and the arsoning of the Serb houses. When we returned to our homes, all people, Serbs, Croats, and Bosniaks. No one is preventing them from doing that. No one is harassing them. We have come across at least 10 mass grave sites, and we are still looking for others because we know that the Sava River is the biggest mass grave site. I might never find mortal remains of my mother. I have personally handed over, together with my team, to David Schwendeman the set of documents recording crimes that were committed in the Brod municipality. I don't see that criminal report anywhere. They never asked us to bring it to the prosecutor's office in Sarajevo again, to bring copies of those documents. Where is it now? I have the certificate confirming the handover in the Hague Tribunal and that Mr. Schwendeman took it over. Don't insult us with these stories without disregarding and not mentioning the Serb victims. Let us not talk about who started the war first, who did what to whom first, and what happened in Bosnia-Herzegovina. Will anyone be held accountable? We should all look at each other and say to each other that we will have to treat each other with respect in future, treat the victims with respect. We need to remember that mothers are still crying for their children, that families are looking for their lost family members. We have to be strong, and we must be firm in our resolution to maintain this course and not succumb to the pressure of the politics. Before I give the floor to Mervan, I must respond to Mr. Mitrovic. I hope you don't. I grew up learning about the massacre in Drakulic. I know everything about what happened there, and that's exactly what as this lady said. How come until 1962 we made so much progress, and we did not take any steps further in the recent past? It's because we are not learning about what happened in the recent past. Mr. Mitrovic, you have a very responsible role in the Republika Srpska. Did you ever stand up to say something against the denial of genocide by Mr. Dodik? I never heard you make such presentations. We are still fighting against each other with our versions of truth. There is no common effort to reach the minimum consensus so that we can leave our children some legacy that they will not fight over in future. And that is why I cannot listen about the year of 1389. I want to listen to your views about how we should deal with the present situation. I am representing the Soros Foundation Bosnia-Herzegovina. Anisa, this is a very current problem, the anonymization of the cases in the judiciary in Bosnia-Herzegovina. Let us please explain to us this initiative, and also I would follow up on what Mr. Refik Hodžić said about the need to take certain initiatives to remedy this practice and invite everyone to join in the discussion. Before I give the floor to the panelists, I will invite Judge Vukoja to explain to us what is the case here from the perspective of the Court of Bosnia and Herzegovina.
Yes. Zahvaljujem. Dakle, sudija Vukoje Dragomir iz...
Judge Dragomir Vukoje, the Court of Bosnia and Herzegovina. At this moment, I will not go into details about this practice. It is more complicated than you think. I don't know if I am the best person to answer this question because I was not personally involved in this. What I can do is to convey your remarks, and I do share your opinion, Refik, about this, and I will convey your remarks, and we will consider it because the citizens and the victims and everyone is entitled to have information available about the perpetrators of crimes, especially those who were convicted by final court decisions. And the results of this conference, I will inform my colleagues in the Court of Bosnia and Herzegovina. I apologize if I did not provide more information in my response, but I hope you will understand my position. Thank you. Then we will follow the order of the presentations. I will now give the floor to Judge Pocar for the final remarks and to answer questions. But I must say we didn't hear so many questions as we heard comments. Koliko imam vremena? 5 minuta. Da, možda nismo čuli baš toliko pitanja, ali pokrenuto je dosta pitanja i barem 3 bih želio da prokomentarišem. Vi me zaustavite jer možda ću imati priliku da se osvrnem na neka od tih pitanja kasnije na završetku današnje konferencije, zato ću biti ovdje sada vrlo kratak. Prvo pitanje žrtava je ponovno pokrenuto. Ja potpuno razumijem frustraciju koju osjećaju žrtve ukoliko njihova lična pitanja nisu u potpunosti razmotrena u određenim predmetima ili da nisu nikako uzeta u razmatranja, jer čak u predmetima koji se tiču nekih masovnih zločina u nekom selu ili više sela naravno da ćemo čuti određeni broj, da je bio određeni broj žrtava, koji je to broj dovoljan da bi se pokrenuo neki predmet, ali ono što hoću da kažem, da broj žrtava nije spomenut pojedinačno u nekim predmetima i da recimo za određene osobe predmeti nisu pokrenuti individualno. To je situacija kod masovnih zločina, ali ja potpuno razumijem vašu frustraciju i zato prije par godina je tribunal pod vodstvom sudije Robinsona poduzeo određeni broj koraka kako bi podigao svijest u međunarodnoj zajednici o ovom problemu i kako bi se poduzele mjere koje nisu bile predviđene u onom momentu kada je MKSJ osnovan, odnosno kada je statut MKSJ usvojen od strane Vijeća sigurnosti. Postoje neke inicijative koje su u toku, ja ne znam dokle su te inicijative stigle, ali želim jednostavno da izrazim svoje suosjećanje s frustracijom koju žrtve osjećaju u ovom pogledu. Drugo što želim da kažem tiče se ovog pitanja predmeta koji do sada nisu procesuirani. Ko je odgovoran za to? Tribunal je imao određene kapacitete, date su mu određene ovlasti za istragu i procesuiranje. Bilo mu je potrebno, tužiocima je bilo potrebno određeno vrijeme da utvrde osumnjičene i moguće počinitelje. Mnogi predmeti su pokrenuti pred MKSJ, 161 je broj, čuli smo. U određenom momentu Vijeće sigurnosti je odlučilo da zaustavi aktivnosti tribunala, odnosno to je bilo 2004. godine, i tužilac je dobio instrukciju da zaustavi istrage. To ne znači da ti predmeti ne trebaju da se procesuiraju, nego da ih trebaju procesuirati sada domaća pravosuđa. To je bila odluka Vijeća sigurnosti. Tako da više predmeta se od 2004. nije moglo pokrenuti pred MKSJ. Ono što je MKSJ uradio je da je prenio informacije domaćim pravosuđima kako bi mogli da iskoriste sve podatke i istrage koje je MKSJ već proveo i kako bi pomogli u što većoj mjeri domaćim pravosuđima da nastave posao. I imali smo određene predmete koji su bili u toku, koji su bili veoma bitni i bilo nam je od velike važnosti da se procesuiranje tih predmeta nastavi. Mislim da mi vrijeme ističe. Spomenuli smo...
We heard a number of
čuli smo nekoliko komentara vezano za obrazovanje omladine. Samo nekoliko puta je naglasak stavljen na djecu. Mom mišljenju, to je nešto na što se mora posvetiti pažnja. Znam da je veoma teško u datoj situaciji, ukoliko su moje informacije tačne, gdje su škole podijeljene i nisu homogene. To je vrlo teško napraviti nastavne planove i programe koji će se primjenjivati u svim školama, ali to je nešto što se mora učiniti, jer obrazovanje mora započeti u ranoj fazi. Ja ne smatram da se djeca trebaju zaštititi od prošlosti, jer prošlost je teška, je užasna. U nekim predmetima, u nekim slučajevima djeca se moraju educirati još u ranoj fazi. Ja nemam vremena da sada podijelim svoje iskustvo u educiranju djece, u mom radu na edukaciji, ali smatram da djeca u školama moraju biti izložena tim sadržajima. Naravno da je to bitno jer djeca imaju veoma dubok osjećaj, u sebi ugrađen osjećaj pravde. Oni znaju šta je pravilno, šta je loše, a šta je dobro. Puno bolje nego odrasli. I ukoliko se pravilno edukuju i budu izloženi određenim sadržajima i činjenicama, imat će vremena da formiraju pravilna mišljenja. Ukoliko se to kasnije radi, onda su podložni indoktrinaciji, raznim vrstama uticaja, tako da je jako bitno podržati inicijative vezane za educiranje djece o prošlosti. I organizatori će vjerovatno biti sada malo ljuti na mene što vam dajem malo više prostora. Da li imate neki komentar vezano za ovu anonimizaciju i praksu anonimizacije gdje se uklanjaju imena počinitelja i drugi podaci? Iz vaše perspektive, šta vi mislite o tome? Kakav može biti rezultat toga? Mislim da je moja kolegica tu već jako dobro odgovorila, tako da ja ću se samo još jednom složiti s njom. Branko? I think that in Bosnia we have pessimists and optimists. We need an objective assessment of the situation in the society in all its sectors. I must say that the outreach program is something that the tribunal lacked, and that is exactly what it needed, the communication and the connection with the communities here where the crimes happened. And that came later only. I think that the lawyers think that if they apply the law then and do their work, and that's all that they should do, they fail to consider the importance of that process for the local community.
I would also like to mention something that was not mentioned today. Two proceedings currently pending before the tribunal, which were expected to draw attention of the public, Hodžić and Mladić cases. The public in the Republika Srpska, and I would say in the rest of Bosnia and Herzegovina and the region, is not too interested in these trials and the impact of these trials on expert community or professionals or various circles is practically non-existent. Let me add in the end that the Helsinki Committee has worked to ensure donors' support, to have an outreach conference for Banja Luka and Sarajevo regarding the legacy of the tribunal. And there was no interest shown by the European Union and international embassies, which means that the focus of the international community, which was a very important facilitator for developments in Bosnia and Herzegovina, has shifted, and it seems that Bosnia has been left to its own resources now, and we lack the initiative and the desire and motivation to face with all these issues. And we are now faced with general distrust, ethnic and religious hatred, and a vicious circle in the civilizational dark that we are spinning in. Let me add to what you said. I believe that we have identified the problem a long time ago, and there is not much that we don't know about the problem. But what we need to discuss is the solution to this problem. We are all aware of the problem, but we need to discuss how to resolve it. And in the spirit of that, can you tell us something, Branko, about the position of the Helsinki Committee regarding the anonymization of the verdicts of the Court of Bosnia and Herzegovina? We have already reacted to this and joined the positions of other non-governmental organizations. We find this highly disturbing and a great concern. We had an excellent cooperation with the court before, and we believe that this practice will pose a problem in future. Alma, the Youth Initiative for Human Rights in Bosnia and Herzegovina, will continue with its activities nurturing the culture of memory. We will encourage young people to take a critical standpoint to their environment and the circumstances they live in. When people say that young people will bring about change, I am highly skeptical. I don't think that young people copying their political leaders and seeking their own career opportunity by blindly following their political leaders will bring about any change. The only young people who can bring change are people with developed critical thinking, with developed individualism, which they can use to fight prejudice, to overcome differences. We allow young people to travel, to go abroad, to see different examples and experiences, and to return to Bosnia and Herzegovina as a valuable resource for the building of a better and more prospective society. Such young people will have a great responsibility in the future, not for the crimes that happened in the 90s, but for the decisions they will make based on the understanding of the history and acceptance of facts, so that the decisions they make are understandable and reasonable and proper, and that will prevent horrors like the one in the 90s from repeating. Anisa and I exchanged some notes during this discussion. The Youth Initiative, in cooperation with the Human Rights Center in Sarajevo, implements the project Youth for Justice. It is a project of young law school students from Banja Luka, Istočno Sarajevo, Sarajevo, Mostar, and Tuzla that will make recommendations for judicial reform. And one of the proposals that will be included for lobbying before the constitutional courts and the Court of Bosnia and Herzegovina and various other stakeholders is the issue of anonymization. Thank you. Anisa? Before I answer Mervan's questions, let me underline the importance of what I have said. As we could hear from the comments following our presentations, the transparency of war crimes trials is crucial for future generations. We did not refer to 1,300 and something or the 40s in the former Yugoslavia only today. We keep referring to those years. Madam, who wrote a book on her experiences in the ICTY, spoke about the problem of lack of transparency about the events from the Second World War, where different families would interpret the events differently and generations grew on different narratives of the crimes committed in the Second World War. We did have an excellent educational system and educative films about the events from the World War II. However, this narrative offered by the system was frequently differing from the narrative offered inside particular families. That is why the trials for the crimes committed in the 90s have to be made transparent. We have to know the identities of the perpetrators, the places where the crimes happened, and the organizations involved in the commission of the crimes. Let me revisit Mervan's question about why the anonymization occurred. BIRN was the first to notice that because we look for all recordings of trials, We were the first to notice that we cannot receive recordings any longer. We were informed about the instruction and rule book on anonymization. The prosecutor's office informed us of the internal decision to withdraw all indictments from their websites, and we sought explanation. It took 2 months to receive consolidated information about the reasons for these decisions in order for us to react and do something. We hired legal analysts and insisted with the Agency for Protection of Personal Information and the court and the prosecutor's office to deliver us all documents they used as a foundation for these decisions. The agency basically said that it was never their intention to influence war crimes cases and that they did not issue any instructions in that regard. The prosecutor's office explained that they made an internal decision based on the guidance of the agency, whereas the court was the only one to pass official documents on anonymization and on relationship with the media, citing in one of the articles as a legal foundation the duty of the court president to manage the affairs of the court. That is quite vague. However, the first verdict was sufficient for BIRN to file a complaint with the Ombudsman's office due to violation of the law on access to information. And we believe that the Ombudsman's office will provide us with an explanation about this. What is paradoxical about this is that the documents were drafted upon the based on the guidance of the agency. There can be a negative and positive consequence of the opinion of the Ombudsman's office. Court and prosecutor's office can take the opinion into consideration in case it is positive and return to their previous practices, or they may not, which would then be another paradox, because why would then they listen to the guidance of the agency but not the guidance of Ombudsman's office? We will certainly seek assistance of all organizations to use all legal remedies available in Bosnia and Herzegovina to resolve this. But what is worrying is the lack of reaction of the international community and the factors supporting the work of the Court of Bosnia and Herzegovina and the Prosecutor's Office of Bosnia and Herzegovina. As it was noted in the first panel today, we have representatives of the international community who are always here. I will not now name them, but at one point they will get tired. There are not many of them who are brave enough to support the judiciary over a long period of time, but we have to gain support for the provision of the European Convention that is a part of the Constitution of this country, that reflects the practices of the European Court of Human Rights, UN Charter of Human Rights, and many other documents. That's something we will all have to work on together. And if the message of this gathering is only conveyed to the court president, that is not sufficient, because the court president has never commented on this issue at all. In relation to this, you can raise this issue in the next panel. We are already ahead of schedule. So, in the next panel, you can raise questions remaining from this one. Let me say two things. My personal opinion is that we should stop referring to international community and stop expecting the international community to resolve all our issues. We should resort to our own resources. We should always discuss things, but with dignity and honesty. And this panel at least resulted in the fact that everyone had the opportunity to say what they wanted. But on the other hand, enough talk already. We are constantly talking about the same things. The same stories keep circulating for years. Anisa, Mervan, people who can do something about this. Let us have at least one concrete, tangible result of this, and that is the use of all legal mechanisms and sending the public message to the Court of Bosnia and Herzegovina that deletion of information from the verdicts has no positive effects on this society. Thank you.